Good evening. This is the first presentation in the 9th Annual Central and Southwest Asian Studies Conference, and we are truly privileged to have a number of distinguished guests and speakers who will be with us for the next few days, and we look forward to all their presentations. Before I start tonight, I want to take the opportunity to first and foremost thank all my colleagues in the Central and Southwest Asian Studies program. First and foremost, Dr. Ardi Kia, who has played a central role in organizing the conference, as well as Professors Khaled Hotheli and Samir Bitar, who have always been pillars of support for our conferences and for our program. I also want to take the opportunity to thank Chip Stearns, William Stearns, who is with us. Chip, thank you very much for all your great work in making the visit by two of our colleagues from Moldova and Russia possible. We really appreciate all your effort. I want to thank Milena Oganessian. Milena has always been with us, and thank you very much for joining us despite a very busy work as a graduate student at the University of Montana. I also want to take the opportunity to thank the staff of international programs and the Central and Southwest Asian Studies Center, in particular Jean Loftus and Brian Loafing, who have been absolutely instrumental in making this happen. Without Brian, this conference would not have been organized. So thank you very much, Brian, for all your great efforts. Tonight, we will have a major presentation, which is, as the rest of the conference, co-sponsored and co-organized by the Central and Southwest Asian Studies Center and the Montana World Affairs Council. And a person that I would like to thank personally, though in his absence, is our friend and colleague Bob Seidenschwartz from Montana World Affairs Council, is a presentation on Russia, on post-Soviet Russia. And this presentation, which is entitled Law, Order, and Judicial Reform in Russia and Former Republics of Soviet Union, will be delivered by a distinguished career diplomat and scholar. Karen Aguilar, welcome first of all, is a career diplomat, a minister consular in the Senior Foreign Service of the United States State Department. She is currently serving as a professor of international relations at the U.S. Army War College in Pennsylvania. Ms. Aguilar joined the Foreign Service in 1980 as an officer in the U.S. Information Agency. In that capacity, she served in Vienna, Austria, and Lagos, Nigeria. She was the senior USIA officer in Burkina Faso, Somalia, and Uzbekistan. In 1999, USAIA became part of the State Department, and Ms. Aguilar since then has served as law enforcement counselor in Moscow, as deputy director and acting coordinator for counterterrorism, as Senior State Department representative to the National Counterterrorism Center, as the director for Pakistan and Bangladesh, as director of the Iraq Transition Assistance Office in Baghdad, and as political advisor to two four-star generals, one American and one French, in Norfolk, Virginia. Ms. Aguilar speaks French, German, Somali, and Uzbek. I wish I could speak all of them fluently. And she's married to another distinguished career diplomat, our friend and colleague, John Fox. And welcome to John on this occasion as well. I should add that the views Ms. Aguilar will express tonight are her own and not necessarily those of the U.S. Armed Forces, the U.S. Army War College, or the U.S. State Department. With no further ado, please join me in welcoming Karen Aguilar.
Thank you very much. I have heard about this seminar, this conference for a long time, and I'm really very pleased to be invited to join you tonight. I'm going to talk about judicial reform in Russia, but this is also, by extension, judicial reform in Central Asia, because for most of the last century, the legal system in Central Asia was, in fact, the legal system of Russia, because it was the Soviet Union and they all followed the same system. They all had the same criminal code, and they all had the same code of criminal procedure. I've lived and worked in both Central Asia and Russia, as you've heard, for several years, and I've supported efforts in many countries to reform or improve or modify laws for various reasons for decades. But I want to make a disclaimer here. I myself am not a lawyer. Are there any lawyers in the House? Is anyone here a lawyer? No? I was hoping that you might want to join in if there were any lawyers here, but if not, then I'll just proceed. I am a diplomat. I facilitate the work of lawyers. I facilitate the work of lots of people who work in the reform arena. And I am also have a lot of experience working with both military and above all with law enforcement people who are working in terrorism, counterterrorism, counter-narcotics, anti-trafficking in persons. And I have to say that when I first became law enforcement counselor in Moscow in 2000, this was before 911 sensitized all of us a little bit more to the risks of terrorism and a lot of transnational threats. When I arrived there, and we were talking about what do you do to improve their ability to have law and order in Russia, our biggest concern there was at the time things like order time and Russia's ability to keep law enforcement effective in its own borders, because these kinds of things spill out and affect us. And what I thought I was going to do, I thought my main job there would be to bring in the various law enforcement experts from all of the United States and have them work with Russian law enforcement to improve their technical and their professional capabilities to be effective in a new system, because the Russian system, the Soviet system had collapsed and the new Russian system hadn't really gelled. One of the things that's a problem, of course, is that they needed to have new laws. And to make from the ground up a new kind of legal system is extremely difficult and challenging. And for them to do this at the same time that their economy was collapsing, that crime was growing, was a huge burden for them. And we wanted to do what we could to help them. We helped them to bring their criminal code into alignment with their international obligations, particularly in things like seizing of assets or counter-narcotics, anti-corruption, again, trafficking in persons, and how to do more professional kinds of investigations and prosecutions than they had been accustomed to doing in their system, which, of course, was more highly regulated and regimented, and the government had a little bit more of an edge in a Soviet system than it does in most Western systems. And this is what I had expected to do, and I spent a lot of time doing things like that. But over the last decade, I've come to the conclusion that it's not our efforts to combat terrorism or other criminal activity that will be our most lasting legacy in Russia and a lot of other countries, but our efforts to help them reform their criminal justice systems overall. Over the years, I've come to believe that of all our forms of assistance and development that we promote around the world, the most profound and the most influential are those that promote justice around the world and help governments to bring justice to their populations. So, arriving there, working with all of these wonderful experts in law enforcement. I was surrounded by FBI, DEA experts, Treasury experts, the Secret Service, Customs. We had everyone represented there in the American Embassy in Moscow, and we were all working together. We also had Department of Justice prosecutors, but I didn't pay as much attention to them at the beginning, because when you go around the room and you say, FBI, what are we doing today? We're helping the Russians to bring down this money laundering ring, and we're helping to do that. And DA, what are we doing? Well, we're having this huge heroin bust, massive amounts of 100,000 tons of heroin coming up over the Afghan border, and we're going to bring that down. And you go, awesome. And then you get to the DOJ lawyer, and he says, well, we're going to revise lines 1,500 to 1,800 of the Code of Criminal Procedure. You know, your eyes glaze over and you go, oh, great. Now, Treasury, what are you going to do? But it turns out that that's actually the thing that we should have been looking at the most in the first place, because that is the thing that was going to have the most impact. It's the thing that affected their justice system the most. And it's the thing that, looking back on that and recognizing that apparently mind-numbingly technical thing that they were working on was actually the thing that was going to do the most to improve human rights of all of the activities that we took, and help to bring justice, change the face of justice in that country. And you say, well, who's justice? And I don't just mean that we go around the world and we nag countries into adopting an American model of justice. We don't do that. We don't do that not because we don't love our system or our system doesn't work or it's not an outstanding system, but because it would be impossible. A lot of our system simply can't be translated into another system because they're based on different principles. They work in different ways. So we look at the comparative legal studies and emphasize international standards that are set forth in various international instruments and agreements that we all look at and say, in order to be part of the international community, your system of justice has to be able to do certain things. So we acknowledge the various legal systems around the world, and we work with these nations to achieve effective and fair administration of justice within those different systems. And we look to those legal systems which are most similar to a given nation, but have made maybe greater progress towards achieving those results. And in Central Asia in particular, we often use the Russian experience as the most relevant for our purposes. And for Russia itself, at the time, for the last decade, we used a number of nations, including France, Germany, sometimes the United States and Britain, and in some cases we even used pre-Soviet Russia itself. So when we first began to help Russia, again, its system had dissolved, and it was open to reform in a way that wasn't possible during the Soviet period, and even 10 years later, the doors would be closing a little bit on that, and the openness to reform was not there. By the middle of the last decade, for example, things were not so open. Russia had gotten more of a grip on its economy. It was simply less willing to take advice from foreign sources. And so, as a result, a lot of what we were able to do with Russia really took place during that decade, from about 1995 to about 2005. So when we talk about that period of reform, that's the time when most of it took place. So we look at that and we say, the first thing they did was reform a constitution. But in that constitution, unlike ours, because our legal system is a different kind of legal system, much of the principles were enshrined there, but it said actual implementation of these rights that we're giving you in this Constitution will depend on your creating the laws that will make it implementable. So the principles were there, but the things that really bound the government had not yet happened. So we worked on other things like a new criminal code, and a lot of us thought the big thing that we'll accomplish in Russia is to help them to have a new criminal code, because a lot of the things that they say are illegal we don't think should be illegal. Some things we think should be illegal, they haven't made illegal. So if we work on the criminal code, we'll accomplish the most important thing that we need to do. Having looked at all this reform by the year 2000 when I arrived, a lot of us in the non-legal field, therefore, thought the big work was done. We said, if we look at something that looks like an injustice in Russia that's inflicted by the Russian government on citizens of Russia, it must be a willful violation of the rights of Russian citizens. Maybe motivated by politics, maybe by abuse of power, corruption, police excess, prosecutorial misconduct. But if we saw something happen in the criminal justice system that looked like a gross violation of human rights, we attributed it to some sort of misbehavior, deliberate misbehavior on the part of the Russian government. Well, all this may have been true from time to time. It may still be true from time to time. What most of us did not realize was that much of the conduct we were witnessing was actually perfectly legal. For all our success in creating a new constitution, a new criminal code that met international standards for human rights, it was still operating under a code of criminal procedure that effectively sapped most of the potency of these reforms. So in 1999 and 2000, we watched all on television. I don't know if you remember this, you're probably too young, but we watched on television as some of the wealthiest and most powerful private citizens in Russia, media moguls, giants of industry, organized crime, political critics, were publicly brought down by the Russian government. We watched as men in ski masks and jackboots, armed with assault rifles and riot gear, stormed banks, banks, not exactly in a position to shoot back, in broad daylight, and stormed residences in the dead of night. They arrested and detained citizens without arrest warrants. They seized anything they wanted as evidence, anything, without a court order. They held suspects in pretrial detention without taking them to a court, getting a judge or any kind of pretrial hearing. They denied defense attorneys access to investigative materials or pretrial files. We watched them hold people without charges. We watched them conduct long investigations while they kept the people in jail without bringing a charge. We watched them start trials while they had people in detention, hold them throughout the trial. We saw them, and in these jails with terrible conditions, we saw them stop trials in the middle if it looked like they weren't going well for them, start them all over again from the beginning, de novo. We saw them lose cases. And then we saw them appeal the acquittal and win and start the trials all over again. We saw them lose again and start again. When they thought they were going to lose, they stopped the trials and started again. We saw judges essentially being the prosecution. Prosecution sometimes wasn't even showing up in these cases. The judges were out there saying, okay, well, doing the questioning, pursuing the prosecution's case, presenting the case file, and the defense wasn't even required to show up. Advocate wasn't even required to show up. And we were outraged. And we were asking for meetings, and we were complaining, and it was the instances of this kind of police brutality or prosecutorial excess or zeal were very frustrating to us, because when we would go in and complain, we simply were not getting a lot of traction from these people. And finally, our Department of Justice people pointed out something that I had sort of missed, which was, that's right. That's the law in Russia. That's the Code of Criminal Procedure. This is all perfectly legal. This is the way the code was written to be, and they're not violating any rule. So, once we realized this, we had a different situation on our hands. We recognized that it was not just that we were looking at some kind of attitude, some kind of lack of a culture of law, or some kind of widespread corruption. We were looking at a systemic challenge. And I anyway, shifted my gears and said, if this is the case, then I think maybe our number one priority should not be sharpening law enforcement skills or pushing too much forward on cooperation. I think we'd better look and see what we can do about changing this system of justice and changing this code so that we can produce something that we in the international community at the very least will recognize as justice, and which Russians themselves will look at and say, this is a fairer system than the one that we're operating on today. Now this, you may be wondering at this point, okay, but they're Russians and you're not. So what is it that one country can do to change the justice system of another? How does the United States change the Russian system of justice? Well, the answer is you don't. You can't. You can never change the system of justice in another country unless you're an occupying power or something. The most you can do is to find the people in that country who think like you and empower them. And use your influence to enhance the will and your resources to boost the capacity of that other government and that population to make the changes. And that's what we did. The system, I want to explain a little bit about this system we're looking at too. Because what they were looking at is a system that they inherited from a Soviet period, but it was one that they'd also had, the seeds of it had been contained in many European systems before that. The system we wanted to change was unlike our system because our system is based on common law and case law and precedent, and their system was an offshoot of a form of European civil law that's based on codes. And in this criminal justice system, there was no adversarial system at all. In other words, you don't have the accuser on one side and the defendant on the other side duking it out in front of a neutral judge who says, okay, this is the law. You don't have that. And you don't have a judge that determines the law and a jury that determines the truth. You have an inquisitorial system in Russia in which a single independent investigative body is supposed to examine the incriminating and the exculpatory evidence, then turn over the findings to a court that confirms that finding and passes a sentence. Well, that was complicated by the fact that there was an entity in the Russian legal system that doesn't exist a lot of other places. In fact, if they're not Central Asian or places that depend on that Russian system or the old Soviet system, and that is called the procuracy. The procuracy is a body that was responsible for overseeing the legality and effectiveness of government administration, including the courts. And this is a holdover from the Tsarist period. This system had, however, mutated over lots of years into a system in which the investigative body was not a neutral one. It was not an independent part of a court system. It was part of the law enforcement system in the Soviet Union. And so you have the same body that's responsible for the investigation also being the body that does the trial. And it's also responsible for overseeing, the same body, the implementation of this court system. It's also responsible for making sure that the court does its job properly. So all of those powers are combined in one entity. And it would be phenomenal in such a case if there weren't some distortions in the best of circumstances. And the Soviet system of justice was, I don't think anyone would call it the best of circumstances for a suspect at any rate. So you have a single body responsible for investigating, prosecuting, detaining, supervising the trial, and reviewing the sentence of a suspect. Once a citizen found themselves in a Soviet criminal justice system, there wasn't a presumption of innocence. there wasn't much that was there to protect their rights. Once the government put something in motion, little stood between the accused and a conviction. The public placed little confidence in the objectivity of the justice system. Lawyers, judges, and advocates for the defense enjoyed very low prestige, very low pay, very few benefits, such as private apartments that were awarded to lots of other government officials. The justice system was not one that was calculated to instill a lot of respect and confidence in the public, into citizens. And I think that when the system of government collapsed in the Soviet Union, a lot of these things came home to roost in the form of people who did not look to courts to solve problems and did not have a lot of confidence in the legal system. So when we looked at what we needed to do to help reform this system, the procuracy was by far the largest obstacle to any reformer's way. And I want to point out one thing here, which is how many Russians were heroically, selflessly, and really nobly devoted to trying to reform the system of justice. When you think about the fact that there was almost nobody who was working in law who wasn't working for the government under that system, when you stand up and criticize your system and try to make radical changes in it, you are putting yourself and your career, your livelihood, many things at risk. And I was privileged to work with these people over the next 3 years, and have to say that I have very rarely seen people with just more moral courage, willing to put so much on the line to get things accomplished. But the procuracy was our biggest obstacle. There's almost no aspect of judicial reform that didn't threaten to reduce its power. If you look at any kind of way that you're going to have a separation of powers, or any adversarial quality, or anything that boosts the defense and to balance the presumption, the bias against the defense, anything that makes the prosecution and a defense equal, anything, making the courts more independent, making law enforcement more independent, making investigative entities independent, all of those are going to have to be pulled away from that procuracy in some way. So there's going to be a very powerful entity out there that, remember, has almost unbelievable power. This entity had the power to override the writ of almost every government agency in that country. It had long been a kind of ombudsman for people, too. So that if you had trouble with a government agency, you could go to the procuracy, and the procuracy could, if it would, intervene. And, for example, a worker's pension payment, a medical benefit, a slot in the university that a student should have had that he didn't get, a widow's room in an apartment complex, those are the kinds of things that the procuracy could just issue a directive to and tell that agency, you've got to do it. And that agency would have to do it unless it appealed to a court. And the courts, under the supervision of the procuracy, they're not all that likely to be that sympathetic. So if the police failed to investigate a crime or a court failed to punish a criminal, the procuracy could order an investigation. They had the authority to initiate a case in that country. And a lot of people had mixed feelings about the procuracy. On the one hand, it was extremely powerful. On the other hand, and it could be dangerous. On the other hand, it could step in and it could help you and cut through the red tape in a place where there wasn't much else you could do to cut through red tape. So they could investigate officials for corruption. They could do a lot. And this powerful entity who could determine who was arrested, who was detained, what could be seized as evidence, who could be tried, what crimes they could be tried for, whether the trial could be stopped and returned for further investigation. All of that was in their hands. They could try you again and again and again. What could you do? This is the entity that most of these people were going to have to stand up and persuade, change this system to give back power. Now, defense advocates had a very circumscribed role in these pretrial events. They were not allowed access to investigative files. They weren't allowed to conduct their own pretrial investigation. It took a long time before they were even allowed to get the right to meet with their clients within 24 hours of an arrest. They didn't have unlimited access to their clients. Their role was largely limited to helping the defendant understand his situation, to advising the court concerning any mitigating circumstances, arguing for the most appropriate sentence for the defendant. Most defendants in that system were, be shocked, convicted. The conviction rate of people tried by judges was, the acquittal rate was like under 1% in many places. Since the early 90s, the accused had the right to meet with an attorney within 24 hours of arrest, but since this was not an adversarial system, the system weighted overwhelmingly in favor of the prosecution. Nobody wanted to challenge this, and so there was not like a huge Russian bar association that was out there putting together unions of defense lawyers. It was very difficult, in fact, to find enough defense attorneys to pull together, even to try to get the germ of a bar association being formulated in Russia. Nevertheless, the need to reform this system was very well understood by Russian political leaders, and this had been made very clear by the European Court of Human Rights, the Council of Europe, who made it very clear if Russia wanted to be accepted into that European system, they needed to make these fundamental changes. So the leadership of Russia said, we want acceptance by, as a serious country by these international standards. We want this. Tell us what we need to do it, and we'll try to make that law. So this was the opening that we seized. We recognized that we could take advantage of that desire to be integrated into the European community. While we had long complained about aspects of this system in the U.S. Human Rights reports that we wrote on Russia every year, we had never specifically linked them up to the Code of Criminal Procedure. But now that we understood it, we looked at things that had been shocking us in a very new way, and we understood that before we could complain about the way the government was abusing the rights of its citizens, we needed to do something that would actually give those citizens that right. So we approached it in a very different line. We decided that we were going to take this highly technical, extremely long, 3,500 lines of legal code and use that to achieve a real breakthrough in human rights. Now, I believe that true reform is never imposed, but comes from within a culture, a society, or a country. So you have to seek out the people, the movements, the institutions in that country that think like you do, that are going in the direction we want to go, empower them in any way we can. And since Russia was not a monolith, we found those reformers. We found them in all different fields. They'd already made progress. We went to them and we said, what's holding you back? What can we do to help you to make this progress? We know we can't do it for you. You guys are out there, you're on the front lines. Tell us what your problems are. And this is where this gets kind of almost funny, because so many of the things that were stopping them were things that were relatively small. No money for translations of key international documents into Russian or vice versa. No interpreters for international experts. No travel to bring people into Russia for programs. This was in the early days. They didn't even have email, and Russian ministries giving people laptops with email on them was a huge advance to bringing people in and linking them. Now, you may sound funny, but these are the kinds of things we did. They were determined to succeed, and they said, it's going to take 5 years, 5 years minimum to get this done. And they said, we got to draft the law first. Then we got to persuade the president to support this version of it. Then we have to get it to the Duma. Then we've got to get it actually signed by the presidency. And then we have to teach people how to implement it. Now, there are a lot of people who said it was never going to happen. And there were a lot of people who said the procuracy will doom it. A lot of people said, who knows? Because we've never even had the opportunity to get all the stakeholders into the same room to discuss it. So we finally looked around and we found the vice chair of the Duma Legislative Committee, who's, by the way, I love the fact that this is in Missoula, because this woman's name is Missoulina, and I think somehow there's a sign there. And he said, what's going on? She said, I don't even know. She said, if I could just get everybody, all the stakeholders, in one place for 48 hours and we could talk it out, I would have a better idea of where we stood. said, so why don't you do that? She said, well, we don't have money to do that. I said, I do. I said, what kind of people are we talking about? How many people? What kind of space? How long? What do you need? Well, we need to get them all off someplace away outside of Moscow so they can't get home. And we got to put them together for 48 hours. And we got to talk about it. So I said, okay, fine. Find me a place. I'll rent a hotel. I'll rent a whole hotel for you for 48 hours. Who do you want? Give me a list. You invite them. We'll pay for their tickets. We'll drive them there, whatever it takes. Just let's get them in the room. Okay, we'll do it next month. And they did. And they came up with 48 principles, which turned out to be the basis of all the reforms that they later did. So it's kind of cool. And I mean, this is simple stuff, right? But this is the thing. At the time, you've got the right instrument, you've got the right people, and these are the people who know what they're doing, and you don't. You don't have to know what they're doing. You just got to know that if you find the right people and they're willing to put the stuff on the line, there are things you can do to help. So what do you need? We need. Well, we can't really use your legal experts entirely because you don't have the same kind of inquisitorial system, and so we really need people to come in who can be more specific along the lines. We need people, from France, and you're Americans. I said, what? We know French people. We'll bring you in French people. Who do you want? So we brought in French experts. We brought in people on bail. They said, just tell us what you need. He says, well, we need 10 experts on this. Fine, bring in 10 experts. We're not sure we want bail. Do you know anybody who's an expert on bail? Yes, we do. And so we'd work with the Department of Justice, and they'd say, the best people on bail are these guys. We'll send them out to you for a week. And this is what we did. They would call it, the Duma would call hearings, and under their legal auspices, they would summon people from all over Russia to participate in these things. And we would bring in experts from all over the world if we needed, if they were experts on the specific thing that was up that they needed to talk about. And here's what we would do. We would pair people. If we had to have prosecutors get involved, I never spoke to the procuracy. Defense people never spoke to the procuracy. We got Department of Justice prosecutors to come in and talk to the procuracy. We had the Bar Association talk to defense lawyers. We would bring like experts to like experts, and we would put them together without any kind of political supervision, and we would have them talk to each other as equals, as experts in their own professional context to see where they needed to get this to go. And every once in a while, we'd bring in some people from the various European rights organizations to say, is this what you were thinking? If they go off in this direction, are they going to be okay? And help them out along those ways. And we took every advantage of every political opportunity. Whenever anyone would come in who would be, Supreme Court justice would come in, we'd set them up to talk to Russian political leaders and talk about how important this process was, what prestige they would have, how much respect they would have in the international community. So whatever it was they needed, you need sometimes such simple stuff. We can't do this because we don't have enough copiers to copy enough copies of this. I'll rent you 10 copiers for a month. It's fine, we'll do that. Or, we can't get this done because we don't have enough legal editors. How many do you need? Are there that many in Russia? Yes. Hire them. We'll pay for them. Whatever it takes, we will get this done. And one time they needed proofreaders. I said, get 50 kids to come here and proof, from college, do it. We'll pay minimum wage. We'll get it done overnight. We did. We had the president ready to leave on a trip at one point, waiting to see if we could get this done. And I said, well, he wasn't sure he was going to want to send this to the Duma until he was sure that this was going to meet the standards that were set forth by the Council of Europe and the European Human Rights Commission. And their experts had actually done a study of it, but it was in German, and his legal experts weren't fluent in German. So we hired 10 translators to translate this study overnight so that we could get it to his legal experts so they could send their assessment to him before he took off so that we could actually get it introduced into the Duma during that session. So these are the kinds of things that we worked with, the ways that we enhanced their ability to do this. We didn't do it for them. We just went and found people who had these abilities and who had this expertise, and we empowered them to do this themselves. We cleared their path. We solved their problems. We encouraged others to cooperate. We worked with every institution that held reformers and some that didn't. And then we used our political and diplomatic influence when it would make a difference and held our peace when making it look too American would have harmed its prospects in some areas. Sometimes just shutting up and doing nothing is the most effective thing you can do to help people achieve some kind of reform in a country. And we respected the desire of Russians to maintain a Russian system. And some of the things about this system that made this so challenging is that it had some unexpected qualities that they were not really eager to lose. They were difficult for us to know what to advise them on. They had a bias in favor of the prosecution that many people felt worked very well for victims of crimes. Victims of crimes could be rewarded compensation directly from the criminal courts in Russia. You didn't have to go and file a different civil case. Victims of sexual assault were allowed to join in the prosecution and participating in questioning from the bench. They were awarded compensation even before verdicts were pronounced. Even though there was no bail, most people were still released on their own recognizance anyway and felt that bail, if they were introduced bail, that would favor the rich over the poor. They had very ambivalent feelings about making that kind of change in their code of criminal systems. The system depended heavily on confessions. There was no plea bargaining allowed or waiving a right to trial. Russians felt that even confessions needed to be confirmed by trial and that only the guilty benefited from a plea bargain. Why give the innocent any incentive, they felt, to plead guilty? Why give the guilty any reward at all, just because it saved times in court? These were some of the issues that were most contentious when these things were brought up, and we had to have the Russians find Russian solutions for these things. We couldn't just walk up and say, this is our system, this is the way we handle it, this is the way you should do it too. Victims of crimes were not really unhappy to hear that the procuracy could appeal an acquittal or a lenient sentence. And this is something that all of us brought up in a system where there's no double jeopardy. What? I said, no, they were right. The guy was guilty. They should have overturned that verdict. And they're right. They gave this guy who mistreated that person terribly. We're glad that they intervened and insisted that they go back and get a higher sentence. So these were things that the European Court of Human Rights didn't particularly like. But a lot of people said, well, why should victims, not have more than one bite at the apple? Why should it just, they should have another chance. So, and why should there not be a new trial if new evidence is discovered? These were things that were very challenging, and it has to be remembered that most of those passing through the criminal justice system were not political prisoners in Russia, that Russian organized crime was a very serious threat, and that not all Russians were eager to hear that criminal defendants would soon have greater rights and protections. Russians wanted a code of criminal procedure that protected the rights of both the accused and of victims. What about trial by jury? It was currently being tested in 9 regions at the time, and it was very expensive and time-consuming. It was not something that most Russians felt was appropriate in all cases. Why would average people be better qualified to hear a case than a trained judge, they said. The rate of acquittal by judges was about 1% throughout Russia. The rate of acquittal by juries was about 15%. Clearly, if you were accused in a system, you might feel a different way about jury trials than if you were a victim. This was attractive to the accused, obviously. But it's also true that the trial by jury was not something unfamiliar to Russia, as opposed to the Soviet legal system, which did away with them. There had been jury trials in Tsarist Russia, and these had been abandoned by the Soviets. It was therefore not rejected as non-Russian when people suggested jury trials. We sponsored lots of seminars on jury trials in the test regions for all the parties involved, and to see if there were ways that we might be able to make this easier to do this, or if it was just too complicated. In one region, upon learning of the need for jury questionnaires, the clerk in that court said he remembered something like that in the basement. And he came back with a stack of dusty papers that had been in use since 1917. These were the old 1917 jury questionnaires used in old Russia. They dusted them off, changed the date, put them right back into circulation. So this was a real adventure, not just for those of us who found this a very unfamiliar system, but for these people looking at a system that had been in use for almost the entire century that they had been around during, and suddenly asked to dissolve it and reform it in a way that meant not just the international standards or American standards, but their own needs and standards was a real challenge for them. So these were the things that we faced. But I have to say that within a year, they had redrafted 3,500 lines of a Code of Criminal Procedure that met the standards of the European Court of Criminal Rights and the Council of Europe. This was phenomenal when you think about it. Everyone told us that this was going to take at least 5 years. From the time that we had that conference to the time that it passed all 3 readings in the Duma and was signed by the presidency, under 13 months. And we did it, well, without spending a great deal of anybody's money. $1 million, but still not that much. When you think about how much we've spent in all of our different things all over the world, and you look at how much you got on that return for that investment, I would have to say that something that is a genuine human rights breakthrough, that for the first time provided a real balance between the rights of the defense and the rights of the prosecution, that made it a judge more of a referee between the sides, particularly in the case of jury trials, extended the right to trial by jury to all major crimes that carried long sentences, prohibited detention for all cases that carried 2 years or less, placed the responsibility for determining detention, search, and seizure in the hands of the courts rather than the prosecution, fixed strict limits on the duration of pretrial detention, and placed limits on the length of detention during trials. It allowed the defense to participate in pretrial investigations, allowed them access to files. It eliminated a form of double jeopardy by eliminating the ability of the procuracy to appeal or overturn an acquittal once it had been confirmed by a higher court. All of these are highlights. This was a hugely long code, and there are lots more things that are involved. But essentially, Russia had a code of criminal procedure that changed the rules in favor of human rights of Russian citizens within the criminal justice system as a whole. Now came the implementation. Did everything change overnight? No. Things did change, and they continue to improve. Corruption, political pressure, police abuse, and excessive prosecutorial zeal still exist, but they're not the law of the land. When you see these things now, you know they actually are breaking the law. This is a difference. So we hear about high-profile violations and standards, and the situations for average citizens continues to improve. The population of Russian jails continues to fall as prosecutors follow the new rules and request pretrial detention in fewer and fewer cases. As the code is further clarified, the results are more striking still. After most economic crimes, or what we call white-collar crimes, were removed from the list of crimes that justified detention, the number of requests for detention dropped almost 10% in 2008 and another 10% in 2009. Judges, unfortunately, have not proven to be the independent and neutral adjudicators that everyone hoped they would be. They continue to exercise less restraint over the prosecution than the prosecution now exerts over itself. It made self-censorship, self-restraint in the procuracy as new people come in, as new people are raised in these laws and more people train in them, seems to be the single greatest change that's taking place. It may be that the change of generation will confirm and fully validate these reforms in practice. There is a huge docket of Russian appeals pending in the Court of Human Rights in Strasbourg, but it's also true that this is at least a part testament to the rise of defense in Russia and a critique of the way the code is applied, not the way the code was written. So for all those countries in Central Asia whose own codes of criminal procedure were once the Russian code, much the heavy lift has already been done by the Russians, and they can, if they wish, use this as a jumping-off point for their own reform processes or not. Kyrgyzstan and Kazakhstan in particular have already made progress, significant progress along these lines. Well, for our part, we can't roll in and tell reformers in another country that what they need to do. But we can make some of the participants in the Russian legal reform available to Central Asian reformers, and we do. We provide them with material that they use. We bring Russian legal experts to Central Asian programs, and we encourage them to watch what's happening legislatively and in practice, and to make their own conclusions about what's applicable and what's not. So, again, I think Kyrgyzstan and Tajikistan are the farthest along in adopting these models, and will obviously continue to be affected by ongoing Russian reforms. We can continue to facilitate communication, exchange between Russian and Central Asian legal experts in the fields, and hope for more reform in these countries. And what's in it for us? I think more justice for our people. I think recent events suggest that the craving for justice is a powerful and unpredictable force in the world, and that helping to empower the forces of reform, and particularly in the justice system, may be one way to channel that impulse into a productive and positive way. So I think that's one experience of legal reform, how it works, what we did, concrete example, and we do smaller things like this all over the world all the time. But this is one particular one that I think had particular application for Central Asia, and so I wanted to share that with you this evening. So if you have comments or questions, I'd be happy to.
Thank you very much. So we have a microphone there, and for those of you who want to raise any of your questions, please use the microphone and use this opportunity. I wanted to ask you just the first question, though. I know that you were involved in Iraq and the reconstruction project, and I wanted to, if you could, just take a few minutes to make a few comments about that, but perhaps make some comparison and contrast with the Russian case. I know it's another topic and completely, but that would be a wonderful sort of topic as well.
Okay, well, it's a huge topic, and of course, what we were doing in the situation in Iraq was very different. Iraq was pretty broken up, and we were reconstructing Iraq, not just helping a completely sovereign and independent country to reform its own systems. We actually had to replace certain things there, and we had a far greater burden dealing with reconstruction Iraq. But there again, when we looked at what we needed to do, the most effective of all of the reconstruction and programs that we did there had to do with finding those people in Iraq who wanted to go, who wanted to see the results that we wanted to see, who wanted to see the kind of development and progress that we wanted to see, and seeing, again, what we could do to empower them. We spent a lot more money and a lot more time and a lot more energy doing things there, but even in areas, for example, like electricity. One of the things we needed to do was help them to establish regulations for electricity, to help them to set up systems and distribution, everything there. The only way you can do that is to go into the country and find the people there who are the experts, link up your experts with their experts, and actually have them work together to address these things. So it's the same process. It is on a different scale entirely. But when you want to look at legal reform, you again put your legal experts together with their legal experts, your electricity people with their electricity people, your water people with their water people, and you have them look at it as professionals and do what you can to make progress within their system and to empower the people the most that you feel are moving in the directions that are the healthiest. So that's it.
Yeah, I have a really general question, actually. What advice would you give somebody who's interested in maybe getting into your line of work, be it working with comparative legal systems or working in the application of international law? What advice would you give?
Well, there is, I think there's a really exciting thing the Department of Justice does. They have a program called OPDAT, and it is in the criminal justice division. It is a program that goes all over the world and works to improve works with other countries to improve their judicial systems. In addition, there are people who work in mutual legal assistance that it is not developmental assistance necessarily, but does things like cooperates on helping to, if you need to try somebody in one country, they will provide legal assistance to that country to help that trial. So I would say you can work for Department of Justice. You could work for INL, the International Narcotics and Law Enforcement section of the Department of State, either as a civil servant, or you could join the Foreign Service and hope that they send you someplace where they ask you to do things like they've asked me to do. But I've really found that kind of work is very satisfying.
Thank you.
And I'm not a lawyer, but if you wanted to be a lawyer, you could do the Department of Justice activity.
Howdy. I have another question as far as I know in the United States has used its diplomatic powers in other countries in a much more heavy-handed manner. And I'm wondering if you could tell me just generally, is this kind of the wave of the future for America as far as diplomatically using it? Or if it depends on the situation, or if you could elaborate on that?
Maybe you could elaborate a little bit more for me. Can you give me an example of a heavy-handed way that we've dealt with something?
Well, this might be out of your jurisdiction, but we could talk about how the Bush administration kind of tried to stage a coup in the Hugo Chavez in Venezuela in 2003. And I'm not, I guess I'm just wondering when it would be that you use a more diplomatic manner and when the U.S. really wants to get kind of more heavy-handed with a different country.
Let's not go into the specifics of that because that's complicated. But what I would say is that we have a vast array of instruments at our disposal in the United States, and I wouldn't necessarily refer to that as diplomatic. We have on occasion actually used our military to go in and attack countries, and that's not a diplomatic activity, that's a military activity. Sometimes we use diplomats, sometimes we use our economic power, sometimes we use our military power, but we have a variety of instruments at our disposal, and it depends on what our security and our national interests are, which ones we elect to use.
Thank you. I'm also looking into being in the Foreign Service, so this was very informative. Thank you.
Take the test.
Chip, and we will repeat your question.
Sure, okay. Say, how far do you think judicial reform can proceed in post-Soviet countries before judges are paid a decent salary? Or before they're afforded a certain amount of respect?
If you could repeat the question.
Right. In other words, how long is it going to take before salaries for people in the judicial system are commensurate with others? Honestly, I don't know. It's something that laws and the status of judges has improved that situation some. As the economic condition in Russia improves, salaries have improved. Salaries started out pretty low, for not just for judges, but for law enforcement. Resources really are a tremendous challenge. I know that at the time I didn't go into this, but these are some of the saddest things. There were places where police were issued a dozen bullets a year, and didn't have handcuffs. So a lot of them didn't have cars. When we would cooperate with them, we'd have to go pick them up and take them someplace. People loaning, our FBI guys loaning the police who were in the middle of raids their cell phones so that they could communicate. These were some of the things that were challenging for them, and so resources and how you prioritize and how you spend them is something that that country has to make up its own mind about. How long it will take, I can't say, but I do think that there are people in that country who are so dedicated to what they do that they continue to do it sometimes under conditions that I don't know how many places would continue to do it out of self-respect, out of belief in what they're doing. And again, I've said I've been honored to work with some of these reformers and people who have gotten by on under circumstances and situations that boggle the mind. So may not be an answer.
Just because it's hard to even recruit people to the legal profession in much of Eastern Europe when they know they go through years of college training and end up in a position with low prestige and almost no money. I mean, the temptations there for graft. Really
That's absolutely true.
Even among nice, well-educated, well-meaning professionals.
Well, it's absolutely true. And of course, it resulted in a lot of law enforcement people having two jobs. Their law enforcement job during the day, and then they would also have second jobs providing security for various organizations, not all of them legal. There would be people, again, who have to have kinds of extra employment because their resources were so limited. And the temptation to abuse your position in order to feed your family or get your kid in school, I think it's a terrible pressure in many countries. So economics have a huge impact on what we're looking at. But you sound like you have some experience in this, do you?
Well, I know the situation in Romania, and I've known a number of Romanian judges, and they face these things. The money has got to come from someplace in order to raise a family, and the most well-intended legal professionals are still involved in what we would consider some rather shady business on the side, by necessity.
Yeah, it is.
Not really because of a moral lapse.
I know, it's a very some places where the police would say, well, we don't have other resources. We're not actually equipped with the kinds of firepower that these guys are. So when we go in, we knock everybody out because that's the only way we can be sure we can handle them. The kinds of things where resources play a role, it's very difficult. But again, there are still some who are just outstanding examples that if everyone could aspire to that, it would make a difference.
Please.
I'm challenged by a couple of experiences that I understand. My roommate here at the University of Montana, four-tour Army veteran, also one of the writers of the Troop Search. And his experience in Iraq was, I'll try to use this politely, in the Tal Afar area, the tribal sheikhs told them, what you guys need to do is fix what you messed up and get out. My belief is that the tribal nature of the Central Asians are not going to be so interested in what we have to say, whether it's through the Russian prism that you've expressed. How are you going to develop a judicial system that's going to lessen their impact in their spheres of influence?
Well, as I said, I don't think that we can. I don't think this is a situation where we go in and we change or we develop a legal system for them. If that impetus is not there, it takes a long time over a series of exchanges. If there is not a body of people who are already there, who already support reform, you're going to be very doubly challenged. And that's, you're looking at a longer term program that means more kinds of exchanges until people do develop some conviction that this is the way they should go. But the international community, of course, plays a role in this as well. A lot of places want to be accepted into by international standards or aspire to meet international standards on things. And so that influence can take a long time, but that's one of the ways you can go. But again, we do have programs. I'm not currently involved in those programs, but I did discuss some of the DOJ and State Department programs that are still operating in some of those countries, and that at least Tajikistan and Kyrgyzstan are making significant progress. But we don't do it. They have to. All we can do is help.
So how are they remedying the tribalism, loss of influence in a nationalistic system? This is what I find to be banging your head against the wall, because why would they give what they already have?
That's an interesting observation.
Next, please.
Hi. So it sounds like the biggest obstacle faced by these people trying to do reforms was funding and logistics, which you provided. Does your funding for this kind of worthy work come from the DOJ? And is it looking at the U.S. political and financial outlook, is it have promised to continue this kind of work in the world where it's necessary?
I think finances affect everything, but the money that the experts, many of them were from the Department of Justice, some were from the Department of Treasury. If there had been a Homeland Security at the time, I would have used Homeland Security people too, but there wasn't. And so the expertise comes from our law enforcement people and our prosecutors in many cases, but also the American Bar Association did a lot of work with the defense sector, which, by the way, was the hardest hit because in Russia, those people had really no source of support. And those that were in the private sector were being sucked off into much more lucrative positions in the private sector, working for companies and not working as defense lawyers. So that was very, very hard hit by money. But all the money that we spend overseas that funds things like Department of Justice programs comes through the Department of State, because the Department of State takes it and then gives it to various implementing agencies to do that. So some of the program is managed by Department of Justice or implemented by various Department of Justice or Treasury, for example, Secret Service, Treasury, Customs, Treasury. Comes through those law enforcement agencies, but the overall policy and assistance coordination comes through the Department of State. And I guess we have to take a look and see what the budget holds for us for the future. But these are not overwhelmingly expensive programs. By and large, what we brought was the ability to coordinate, the ability to provide them with some resources, and to provide a focal point where everyone could come and we could then pull people together. So we had a kind of, we worked their own interagency for them at times. By, if Department of Justice didn't want to talk to, not Department of Justice, if their procuracy didn't want to talk to their defense people, they didn't want to talk to their Duma, we might individually send our, prosecutor to prosecutor, defense to defense, and then talk to each other so that we could try to do some circumlocution. So it was not just money, it was also the kind of expertise that we would put in touch with their expertise. But I find that worked sometimes a lot better than just having diplomats go in and talk to their diplomats. That you'd get a lot more progress if you had the experts talk directly to the experts on their own, in their own plane of existence, so to speak.
So this also is quite general, so I apologize for that. But I'm curious, you were speaking about the role of our diplomacy as promotion of justice for more people. So more justice for more people. But the concept of justice, to me, I wonder if it's culturally bound, and I know that we have our flavor of justice that we think about. And I kind of wondered, because you have so much experience in so many different countries, what you have come to understand about the variation of that concept of justice between different countries, and basically whether or not multiculturalism, whether there are different lenses to look through when using justice. Now, lots of the examples you mentioned about promotion of justice sometimes we talk about violation of human rights, they're so gross that under any account of what is justice, they would certainly fall. But have there been times when it was ambiguous? A situation may, under one person's idea of justice, be different than another's?
Oh, absolutely. And I think I even mentioned some of those where I said sometimes things to us, double jeopardy. What do you mean you can keep trying this person until you get the result you want? That's unfair. To us, that seems outrageous. And yet there were people to whom I spoke who said, well, if the courts let somebody off who's guilty and you find new evidence, why shouldn't you be able to try them again? And they said, you mean if you found the actual evidence that this person committed this crime and you'd already tried them and acquitted them, you couldn't do anything in your American system of justice? That's stupid. To them, that was unjust. But that's a kind of more technical thing. I think by and large and this is just me talking, this is not me as a professional diplomat, but I will say this. I think that there is something visceral about a feeling of unfairness and justice. I'm not talking about justice systems or even laws, because that's more technical. But I do think that there are times when it's a belief that your system is not providing you with justice. can be a tremendously powerful thing in a population or an individual. And even things like insurgency or terrorism, I think that feeling impotent in the face of a real or imagined injustice can be an impetus for people engaging in acts of terrorism or insurgency. And so that kind of thing is something that I think, regardless of what it is that you think is just or unjust, not seeing it in a system can be destabilizing. And so I think we have an interest in promoting justice around the world, at least effectiveness in the administration of justice. So. Thank you.
Following on this interesting question, although general, but very interesting, and going against the grain, and maybe I like to go against the grain, but I apologize. It's in my blood. I can help it. I have French origin. You know. You have spoken about this we, them, which is fine. But as an expert, what do you do with contradictions? How do you take them into account, especially when you come from a master position? I'm going to try to improve your system to give you some of the truth, if not the truth. I mean, for instance, that America has the largest penile population in the world. I don't know if it's perhaps meaning the justice system works perfectly here, or it's flawed. As you said yourself, in Russia, the penile population has decreased because of a better justice system. So you see what I mean? Like if you stick up 9/11, you are Native American, Indian, or black, you get 10 years, 15 years. If it's a second or third offense, maybe 20. If you are Mr. Madoff, you get up with a few slap on the, some years in a federal prison, which is not too bad. So there are contradictions. So as an expert, how do you convey those contradictions? How do you avoid them? How do you take them into account? Or does that relativize your approach? See what I mean? I'm not being catty. I'm just.
No. I'm not sure. I do see what you mean. We all talk about things like the actual system itself, the law that you've written, the system that you follow, and then there's the implementation. For example, we talked a little bit about the European Court of Human Rights condemning the system of justice because it didn't even have a law that met the fundamental standards, versus now with all of these cases in the docket saying you failed to live up to even your own standards. So there are all kinds of contradictions in the world. And I don't say I'm an expert at law. I say what I do is to help facilitate experts, work with other experts to accomplish things that meet more international standards. So that's as far as I'll go to claim any kind of expertise on this area.
Thank you very much, Karen.
By the way,
you wanted last comment?
I just did want to say, by the way, one of the things that we used extensively was the French legal system, because it was the closest thing to a system. When we were talking about Russia, they wanted a system that had a kind of a juge magistrates system in it, that had an independent investigative body, and that was still not an adversarial system. So trying to find some balance, very often we went back and actually looked at bringing in French experts to help them to work on that. So we didn't just look at one system. Anything else?
Thank you very much.
Okay. Thank you very much.